Welcome to an oral argument session of the 5th District Court of Appeal. I am Jay Cohen, and it's my honor this morning to sit on a panel with Judge Dan Traver and Associate Judge Letty Marquez. Let me remind you that we are on YouTube recording this, and so just to keep that in mind, we appreciate if you would keep your volume muted until such time as it's your turn for the oral argument. This is case number 19-758, Green Shields versus Green Shields. Both sides will be entitled up to 20 minutes each for their argument. The appellant will, now we have a cross appeal on this too. So we've got, 5 minutes default on rebuttal. If you would like something different than that, just let me know and I'll be glad to make whatever adjustment to that time that you would like. So that said, we're ready to proceed. Mr. Yardley?
I am, sir.
Okay. Go ahead.
I'm sorry, I thought we were, yes, sir. May it please the court. I'd like to split 10 and 10 if I might.
Okay.
And in this complicated factual scenario, there's a couple of simple rules that the court didn't follow. And in analyzing it last night, when I'm trying to put it all together, I think what happened to the trial court judge is he forgot the distinction between law and equity. In the 1956 merger of the two independent systems of jurisprudence, there is equitable causes of action and there are legal causes of action. In this case, the judge took a contract action, an action at law, and he gave it the aspects of an equitable action involving injunctions and relief, but he didn't follow the requirements of the equitable action. Most significantly, he did not require the former husband, the plaintiff in this case, to post a bond when he tied the mother defendant up in the legal system. And I think that's where the judge went wrong. And I think he continued to be mixing up the two remedies at the end of the case.
Right, let me talk specifically about a couple issues that you raised. You make an argument that this was an interest-free loan, correct?
Yes, sort of, Your Honor.
Why don't you read paragraph 6 and 7 of the power of attorney and explain to me how that provides for an interest-free loan?
She was not going to pay him interest. What she was going to do is pay
him.
I
want you to look at paragraph 6 and 7 of that power of attorney and explain to me how that language provides for a interest-free loan.
While I fumble through the papers, Judge, it says the cost of acquiring the loan. And what our position is, if he went out and borrowed money.
If you get those paragraphs, you're going to see that it includes interest.
Where was that? That was in their brief. In sight of that.
If you'd like to come back to it, later.
Yeah, I would, Judge, because I don't think that matters, because he should have asserted that when he got sued in Brevard County and went to mediation, because that's where I think the judge also went wrong. Everything that Mr. Greenshields had against Mrs. Greenshield in the two lawsuits was resolved when they went to mediation.
Well, I don't know how you can make that argument.
Really?
There were a number of things, and I recognize what I wrote in that earlier opinion, and I recognize I'm going to eat my words on it now, but let's talk about the whole concept that you argue that it was a compulsory counterclaim. I'm struggling with how a suit on a power of attorney as to a contract, as to a financial agreement, is the same as a suit on the marital settlement agreement. How can that be a compulsory counterclaim?
Why don't you, when two parties are at odds and one of them sues the other party about something, and in this case, let's say it's the $20,000, every claim, every issue to that same $20,000 has to be raised in the lawsuit. How can that not be a compulsory counterclaim? They had the sale of the property, and she took from the sale the money that the husband owed her. And the husband said, no, that's wrong. I owe you a different number, or whatever he said. So once she snatches the money out of the closing and then sues him for a determination that she's entitled to that money, his claims, his competing claims to it are waived. Why is that not a compulsory counterclaim? She
Well,
says,
let me ask it this way. Imagine that the situation was reversed and she hadn't sued first in the family law case. Let's
Right.
say, by contrast, that he sued her first in Orange County in circuit court for breach of contract.
yes, sir.
Is she compulsorily required to then sue him under the marital settlement agreement in the same case?
Absolutely. 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 Because they're fighting over the same $20,000. It's not a
Why?
different. Well, because
I
it's
mean,
from the-
so if her argument is you're delinquent to me on alimony,
right.
how is him suing her on the power of attorney require her to raise alimony claims?
Because it comes out in the math on who owes who. If you sue me because you say I owe you money, I have a claim that says no.
Your argument on it being a compulsory counterclaim is that it comes out in the math? That's the argument?
Over the same $20,000, over the same transaction.
No, it's not over the same $20,000. One involves interest on a contract. Now, and the other is an issue of whether alimony has been paid. One's on a contract, the other
I'm
is in a
sorry,
family
Josh, I
law
thought you froze
context.
up. It's the contract was for the purchase of the house, right? They went back and he was going to lend her money so she could buy a house so she could move closer to him. That's what the power of attorney was for. That was the object of the contract. And once they reached that agreement, the loan was in fact made, then he was entitled to get paid back. That's without question. She never acknowledged, she never said, I don't owe you the money. Her point was, I don't owe you what you say I owe you a lesser amount. And by
Let me ask you this, Mr. Yardley, just kind of in a straight hypothetical fashion.
Yes, sir.
Say you lend me $100.
Yes,
I
sir.
pay you back 70.
Right.
There's a dispute over 20. And ultimately you end up saying, you know, Judge Schraber, keep the 20. Can't you still sue me for the 10?
Why did you lend me the $100?
Well, my hypothetical doesn't involve anything other than just a straight exchange of money. So let's start there. If you lend me 100, I pay you back 70, we fight over 20, and who cares what happens with that 20? How come you can't still sue me for the 10? You're owed it, right?
Because your hypothetical doesn't, in the real facts of the case, you lent me the 100 because you and I have a child together and you want me to move closer to your residence and I'm going to relocate my residence so our child can have a closer relationship with the two of us. So you want to go back to the reason. That's why I think they're interlinked, because it relates to the reason why you lent me the 100. You didn't just lend me the 100 because I needed 100. That's a different factual scenario. You lent me the 100 because you wanted me to move closer to you.
Mr. Yardley, wasn't the discussion over the 20,000 in the mediation case in Hard, wasn't that actually simply a discussion of the source of the funds that were going to be used to pay alimony and not a discussion of the POA at all?
Judge, you echoed at the beginning of your sentence.
Yeah, we have a weird echo. I apologize.
No, I didn't hear you.
Why can't we just look at what happened during mediation? That $20,000 was merely a source of funds for back alimony to be paid and not litigation on how much was the appellee was entitled to, the husband was entitled to under the sale of the property. All they were talking about was, how are you going to pay this alimony? Here's this $20,000 that I can take to make the alimony arrearages good, as opposed to, this is all the money I'm entitled to under the POA. What evidence is there in the record that what they were discussing at that mediation was all of the money he was entitled to under the POA?
Well, see, Judge, there's our problem, which is the confidentiality of mediation. These people came into mediation with a laundry list. They had a list of grievances a foot long. I mean, we had so much petty stuff. There were 40 different items of discussion, but what they said at mediation is privileged under the rules of procedure. So we couldn't bring out what was said at mediation.
And Mr. Yardley, you're into your reserve time.
Well, that's good, Judge, because I'd like to sit down and get the exact language of the contract so I can respond to you intelligently.
All right. Mr. DeWitt.
Thank you, Your Honors. May it please the court, my name is Moses DeWitt, and I represent the appellee cross-appellant Mark Greenshields in this matter. And I'd like
How
to
much
reserve the
time
stand
are
for
you going
5
to
minutes.
request for, how much time do you need for rebuttal?
5 minutes, Your Honor.
Okay.
Thank you, Your Honor. Your Honors, it was error for the court to find that the claims brought by Mr. Greenshields were compulsory to the claims brought by Mrs. Greenshields in the lawsuit for alimony and child support. Frankly, if you look at the case that Mrs. Greenshields in Brevard County, the case was filed and then a notice of voluntary dismissal was filed about 5 months later. I don't actually think you even get to the analysis of whether it's a compulsory counterclaim or not, because there was never an adjudication of the merits in that case. I think what controls here is the settlement agreement from the Orange County case, which says she's going to dismiss the case. And that settlement agreement does not state anything about Mr. Greenshields' claims on this loan to Mrs. Greenshields, and does not bar her from bringing those claims at all. It'd be no different than a release in a personal injury case. The release here, or the settlement agreement here, does not preclude Mr. Greenshields from bringing these claims. It's very clear. And I think the appellant here is trying to read things into the settlement agreement that simply are not there. It does release the $20,000 to her to satisfy the alimony and child support claims, but there is nothing in that Brevard suit, which again, I don't think you even get to. There was nothing in that Brevard suit related to this loan. This loan was clearly after the divorce. It was not related to the divorce. It's not related to the marital settlement agreement. It's very clear on those
Mr.
matters.
DeWitt, can I ask you about your argument as it relates to the tortious interference counterclaim? It seems to be sort of a tipsy coachman style argument that tortious interference could never be an appropriate counterclaim regardless of the situation. I guess the challenge I'm having with that, and I'm hoping you might be able to address it for me, it doesn't appear to me that at any point below your client raised an affirmative defense to that level. There was no dispositive motion that was filed. I have a little bit less heartburn about the idea that it wasn't addressed at trial because it was thrown out completely, almost without you asking for it. I'm wondering what ability we have to address that issue for you for the first time on appeal, as opposed to if we send it back for another trial, it being addressed in the first instance back then.
Well, I think you could do it either way, and you are correct. I think the only way that you could address it here today is via tipsy coachman, essentially saying, the judge didn't state a proper basis for dismissing this, but pursuant to tipsy coachman, it should have been dismissed anyways. Or you could send it back with instructions if you so chose to. Say pursuant to this case.
Mr. But it looked to me that the judge denied the tortious interference claim rather than dismissing it, albeit before Mrs. Greenshields was given an opportunity to put on any evidence.
I'm not really sure what happened there. There was a flurry of orders or opinions being stated by the judge at that point, denied or dismissed. Either way, I think both claims were essentially thrown out at that point, and then damaged award claims in some manner or fashion, which I don't think was proper either. Even though it partially benefited my client, I don't think that there's any case law to support the fact that a judge can deny a claim or dismiss a claim. And I'm using the words interchangeably here. There may be a distinction, and then award damages after that. So in that regard, I would concede that there was error, even though it did benefit my client in that regard. As far as the tortious interference claim, again, I think the only way to it was not raised below. I have to concede that had it presented at trial, and his case in chief would have gone to trial, or Mrs. Greenshield's case in chief would have gone to trial, it could have possibly been included as part of a directed verdict at the end of their case. Obviously, this was denied or dismissed prior to their case even beginning. However, pursuant to Tipsy Coachman, I do still think that this court has the ability to uphold the denial or dismissal of the tortious interference claim going forward. With that, Your Honors, I apologize.
I'm sorry, I forgot to unmute again. Your position is that the power of attorney wasn't addressed at the mediation?
I wasn't at the mediation. What was discussed in mediation obviously is confidential and privileged. I think the face of the settlement agreement here is clear. It controls. It's just like any other contract. It's clear. No one's ever argued it's ambiguous, and the terms of that contract have to control. There's nothing here that waives any claims related to the power of attorney or the loan. I think it's pretty clear cut. I don't think we can read things into that settlement agreement that simply aren't there. It's a separate lawsuit brought in Orange County, and the divorce case and the family law case has nothing to do with these claims. And arguing that the source of funds somehow makes my client's claims deemed moot or dismissed or waived, I don't think there's any proper authority to support that claim.
I have a quick question, and I don't typically ask about attorney's fees motions during these oral arguments, but you seem to be making an argument to entitlement for attorney's fees based on the power of attorney, and kind of in the spirit of Judge Cohen's first question to Mr. Yardley, where does it say that?
I believe that there was a recovery, and
you agree with the just general proposition of law that in Florida, we look at these things pretty strictly, that there has to be a clear entitlement to fees. It has to be from a contract or a statute. Obviously, we don't have a statute at play here. You're claiming entitlement based on the power of attorney. Can you point out for me the specific language in that POA that gives you a clear entitlement to recover attorney's fees?
Would it be okay if I took a look at that during my break and address that in my rebuttal, Your Honor?
Yes, sir.
Okay. Unless there's any other questions from the panel, I'll reserve the rest of my time for rebuttal.
All right. Thank you. All right, Mr. Yardley. Are we going to start by talking about paragraph 6 and 7 of the power of attorney?
My attorney, in fact, will receive no compensation except for the reimbursement of all out-of-pocket expenses associated with the carrying out of my wishes, in addition to 100% of the cost of loaning me the money to purchase my new property and the address, including any interest paid by him on this loan and any other costs directly associated with it, as well as any expense. The point of the contract was not that he was going to gain interest on the money that he lent her. The point was he wouldn't cost him anything. all of the expenses that he incurred in getting the loan would be reimbursed by Mrs. Greenshields. That was what they agreed to. So I think that's why I say he doesn't get interest on he doesn't get the time value of his money because he didn't bargain for the time value of his money. He specifically said, if I have to go out and get a loan and I have to pay a loan origination fee and I have to pay 3 points on the loan, whatever, all that would be paid back by her. And Judge, you scared me when you said that you're going to have to eat your words, because we take your opinions in a case as a roadmap. And when the appellate court says something is the way it is, that's the way we approach the case because we got guidance from the appellate court. So I'm asking you not to eat your words. And I really, I don't understand why you guys are not focusing in on this particular contract. This written document that he prepared is the subject of the litigation. They had two separate cases, one in Brevard County, one in Orange County. They had a list of grievances as long as your arm, children's cheerleading fees, as well as all the issues set out by this sale. The time for this person to raise his complaints with his ex-wife was at the mediation session. And it should be a speak now or forever hold your peace sort of thing.
Don't we, in order to figure that out, don't we look at the language of the mediated settlement agreement as to what was settled and what wasn't? Otherwise, I think you have to concede that we have no idea what happened in mediation.
I'm saying that that when parties to a dispute wind up in front of a mediator and these people have two disputes going on, and remember that the Brevard County dispute was explicitly mentioned. He bargained for the dismissal of that case. She was suing him for a determination about whether she owed him money under this same contract. That's why she said that was the subject of the Brevard County suit, the same thing that he sued for in later with the lease pendants. So
there's to be accurate, there's two paragraphs in the background section of that complaint. None of the specific causes of action relates to the power of attorney. None of the specific prayer for relief relates to the power of attorney. And then in the mediated settlement agreement, there's no reference to compromising the power of attorney. So if he was bargaining away a civil lawsuit, why didn't you ask for a release of that lawsuit in the mediated settlement agreement?
Because everything, the slate is wiped clean between these two. These two were at each other hammer and tongs over multiple issues. Why is the issue that when she gave up claims when she took the money? She now is able to get every picky little claim she had between him? No, sir. He should have said, when she said, this is my $20,000 that I got out of this closing, he was obligated to say, oh, no, it's my $20,000. You have no right to it. You signed a power of attorney. That's my money. That's the obvious counterclaim to her claim. But he didn't.
Another plausible way of looking at it is that she paid him back the 70. He agreed that she could keep the 20 to compromise the alimony, and then he sued her for the 10.
They weren't suing for anything. They were concluding their problems. They were resolving their issues. They were putting a cap on everything that they had. All of the petty bickering they had back and forth was all capped up in the agreement. She wasn't going to.
I understand that's the theory, but where in the mediated agreement does it say that? Other than she agreed to drop the Brevard County lawsuit where she mentioned it twice in the factual background.
She agreed to drop the Brevard County lawsuit because she was getting what she wanted. There was no point in the Brevard County lawsuit once he agreed that she could have the money. So why pursue the Brevard County lawsuit when all of the issues in the suit were resolved, some of them to her favor, some not? All of the issues that she raised were disposed of at mediation, which was then reduced to a final judgment. So that's why all of his issues are precluded. All of his claims are precluded. You can't have a situation where people cagily, if they want to leave out an issue, they got to put in, I'm not, instead of wiping the slate clean and going to have a final judgment, he needed to say, this does not resolve my claim that you owe me the $20,000. And Judge Cohen, this was the same $20,000. That's not in dispute. It was the 20. The money that they were fighting about was the same money all the time. That's why the issue is precluded. That's why the claim is precluded. That's why, and then we're not even getting into the fact that we let him take advantage of her by filing the lease pendants and screwing up the sale of her house, which he should not have been able to done. Everybody agrees that that lease pendants was wrongful. I see my lady as the victim here. As for the tipsy clothesman, Claire Greenshields wants this case done. You've got a wealthy husband litigating with a store clerk wife over family issues back and forth. She doesn't care about whether she has extra damages. She wants the case done. But the trial court judge shouldn't have gone back in and then pulled out an item that was resolved and put it back on the table, particularly in light of the fact that he didn't have any evidence of it. That's the other issue that we're forgetting. He had a whole trial to present his compliance with the agreement and to show in evidence the cost of the 100% of the cost of loaning him the money. Where's the documents in the record showing the cost of loaning him the money? What origination fees did he indicate? Where is any of that in the record? It's not in the record because he didn't introduce any evidence of it.
He testified that it was 3% rate and that he gave an extra point for not paying it back. So, I mean, isn't his testimony, when we're looking at a directed verdict, in the light most favorable to the non-moving party? How come that in and of itself doesn't pass the test?
That's a good point. Because it was all assumed, every one of his claims to this. Go back to the email traces where they're squabbling back and forth. Give me the 165, give me the 160, give me the 165, throw in the insurance money. All of those issues that were in play in all of their correspondence back and forth were resolved by them at mediation. You can't go into a mediation.
You're making the argument, and I think you admirably stated so in your briefs. You concede that the mediated settlement document is an unambiguous document, correct?
Of course it is, Judge. It's a mediated settlement agreement. Yes, sir.
And I think you also have to concede that there's no release of the POA in that settlement document. There's no release of any claims that the husband might have against the former wife in that settlement document. In other words, we don't know what was discussed at mediation or what they might or might not have agreed to. We have to look at that unambiguous settlement document, and that stuff just isn't in there.
I don't concede that second point at all, Judge, because the evidence was at trials that she revoked the power of attorney. So, but long before they went to mediation, she disavowed that power of attorney and told the world that she was no longer bound by it. So that dispute occurred in April before the sale in June. So that was on the table. Any rights that he had under the power of attorney were discussed at the mediation table because she said, I'm not abiding by that. That's ridiculous. I'm not accepting that anymore. But she always agreed that she owed him the money that was borrowed. Her point is, I owed him money. I went into mediation. I worked out who owed what to whom, and that should put an end to it. And that's the end of the case.
All right,
and we're done.
Mr. Yardley, your time's up. Just one last quick question, which is, do you acknowledge that it was error to award damages after the denial of the tortious interference claim?
No, because you have the damages which were occasioned by the wrongful lease pendants.
There you go. Okay. That answers the question. Thank you, sir. All right, Mr. DeWitt.
Thank you, Your Honors. I'll start by going back to Judge Traver's question. While the power of attorney doesn't specifically address attorney's fees, Paragraph 6, subsection 3 does list one of the powers as to ensure that Mark Greenshields is made completely whole. And then under paragraph 10, it does state that my attorney shall be entitled to reimbursement of all reasonable expenses incurred as a result of carrying out any provision of this power of attorney. So therefore, I would make the argument to the court that he is entitled to reimbursement for essentially enforcement of the power of attorney by having to bring the lawsuit to collect to ensure that Mr. Greenshields is made whole.
Mr. DeWitt, did I misread paragraph 6 and 7 of the power of attorney as it related to interest?
I don't believe you did, Your Honor.
Does it provide that he's entitled to interest?
That's the way I read it, Your Honor.
Right. What language do you cite for that?
Let me pull it back up here. I apologize. What does say 100% of the cost of loaning the money to purchase the property at Falling Star. So a cost incurred of loaning the money would certainly include interest. I think that's just standard by definition.
Okay. Is that both in 6 and 7, paragraph 6 and 7?
I believe I was referencing paragraph 7. Paragraph 6 has more extensive detail or extensive language that does say I apologize, I'm reading it here. Does say mortgage, charge, lease, manage, or otherwise deal with real estate and any interest therein, and execute and deliver deeds, transfer mortgages, charges, leases, assignments, surrenders, release, and other instruments required for any such purpose. So there alone, I believe it would give him the authority to loan funds that would collect interest in relation to the Falling Star property. And then it does say in full repayment of all and any advances, including interest, insurance, utilities. So I think it pretty clearly includes interest there, at least the way I'm reading it. Your Honors, I would ask that this court reverse the trial court's dismissal or denial of Mr. Greenshields' claims and remand for a trial on appropriate damages. However, we would ask that that this court uphold the dismissal of Mrs. Greenshields' tortious interference claim pursuant to the tipsy coachman doctrine, but find that she's not entitled to damages for that claim. Unless there are any other questions from the panel, I will yield the rest of my time.
All right. Thank you for the argument, and we'll be in recess.
Thank you, Your Honors.